My name is David Geneson, and I am a trial attorney. I practice predominantly in the District of Columbia and in other jurisdictions from cases that are brought to me from various locations throughout the world. I want to talk to you about exhibits today. Exhibits are predominantly two types, demonstrative and real. Demonstrative exhibits are those type of exhibits which you used to show by example a trier of fact, something that has transpired or something that is of particular interest during the course of the trial. They are often used to explain a particular situation in a physical and or overtly visual manner, such as a map, a diagram, or something of that quality. The qualifications that one would use to bring in a demonstrative exhibit are really set by the trier of the case himself or herself, and they are done in a manner which is essentially a simple question of whether or not the exhibit purports to represent what it should represent. For example, if one were trying to show simply an intersection of two streets at 90-degree angles, you would draw two lines, or four lines possibly showing the width of the street, and in the course of doing that, merely ask someone who had been at that location at some point in time whether or not it fairly and accurately represented the intersection of those streets. That's a demonstrative exhibit. Similarly, if one wanted an example of a gunshot, one could fire essentially any gun in the courtroom, assuming the judge would allow that, as an example of a shot. If it was a particular type of sound, such as a .45 caliber pistol, you'd want the example of a .45 caliber pistol. It would not have to be necessarily the pistol that was the key pistol in the case, assuming it was part of the case, but if it was merely the sound of a .45 pistol going off, one could fire any .45 pistol. Alternatively, we have real evidence. Now, real evidence comes in essentially three types in terms of exhibits. That which is the onlyest, that which has been made the onlyest, and that evidence which is susceptible to a chain of custody, which means it has maintained its integrity since the time it was first obtained and it's now being presented in the courtroom. That which is the onlyest is a unique item. For example, let's say there is a jewel, and we'll call it the Rabinowitz ruby. We would bring to the stand an expert in jewelry, someone like Harry Winston, a very famous jeweler in New York. And Harry Winston could identify the Rabinowitz ruby because he is an expert and because it's a famous jewel. There's only one Rabinowitz ruby, and Harry Winston knows it. He could identify and therefore move it into evidence, assuming it is a relevant item for this particular case. Something which is made the onlyest can be anything, albeit it must be relevant to this particular lawsuit. For example, a letter. A letter is just a document, a piece of paper maybe, with writing on it, either typewriting or handwriting. But to the extent that it has been made the onlyest, someone may have put their signature on it. That person, or a person who knows that signature, can identify that document and therefore say it is now the document which is relevant to this lawsuit. It has been made the onlyest. Finally, we have the subcategory of the three real types of exhibitory evidence or exhibit evidence, which is chain of custody. For example, we have narcotics. Narcotics is a classic example of evidence that has to be put in by way of a chain of custody. Essentially, the government, presumably, is the one presenting the case, and they would want the officer who picked up the narcotics at the crime scene, who has maintained the narcotics, the chemist who has found it to be narcotics, the officer who received it from the chemist, and eventually the person who is bringing it into the courtroom. All those witnesses nominally would be required to be presented to the trier of fact to show that that evidence has not been altered in any substantive way during the entire time from which it was first seized until now being presented in the courtroom. Interestingly, there is a line of cases that the Supreme Court has found over the last 5-6 years which have made that requirement that much stronger than it used to be. Typically, in the old days, one could present such evidence essentially by stipulation, agreement that the chemist had made a finding, agreement that the officer had maintained the information, the documents, the materials, that which is subject to the chain of custody in a proper manner. But the Supreme Court now requires, as a result of a line of cases, that you actually bring in the person, for example, who has made the finding, the chemist who actually analyzed the cocaine or the other drug, the analyst who has done the blood sample on a DUI case. That person must be presented in the courtroom. So chain of custody has been revived and is now a much more important way of bringing in evidence, and now has much more stricter evidentiary requirements. In effect, it is important to remember that also, when it comes to moving in real evidence, you don't have to use more than one of these three foundations. Only one is necessary, one will suffice. Either that which is the onlyest, that which has been made the onlyest, or the chain of custody. Thank you very much.